All right, guys, welcome to the Street Cop Training Podcast. We are back again for the second week in a row. This is episode number 2 of this session between me, Dennis Benito, I'm the founder of Street Cop Training, and Zach Miller is an instructor with our company, a legal expert in Fourth Amendment search and seizure. We're glad to have him. As I say always to everybody I meet, Zach Miller is a blessing for this company. Without further ado, we're going to get to this week's topic with Zach. And the first thing we're going to start with is the automobile exception and some things regarding the automobile, keeping people in cars. Can you search people when you develop probable cause? And we have enough time to go into Arizona v. Gant in this episode. So introducing Zach Miller. Zach, go ahead and take it away. Let's go into probable cause to search a car and extending it to passengers in a vehicle and your position. And I'm going to jump in here. We didn't have a lot to talk about prior to getting into this podcast episode, but I was just in Kentucky. There's an interesting piece of case law there regarding canine alerts and what they said. So I'll bring that up to you as we go along. Go ahead. Yeah,
that's going to lead right into what we're talking about. So we got probable cause to search the car. And it doesn't really matter what the source of that probable cause is. Is it a canine alert? Maybe you smell marijuana or you see something in the car that gives you probable cause to search the car. Under the automobile exception, we're good on that. We covered that last week. So what about the occupants? Can I search the occupants? And the answer is no. The probable cause to search the car by itself is not probable cause to search the occupants. You need a person is a separate constitutionally protected area. A vehicle is in effect. That's one area. But to search a person, you need probable cause that's particularized to them. And just because you have probable cause to search a vehicle doesn't necessarily mean you have probable cause to search the person. Now, I'll talk about Anchondo here in just a second and the cases that tend to follow Anchondo. But the leading U.S. Supreme Court case on this is a case from 1948 called United States versus D. Ray. And that was a case where they had probable cause to search the car for evidence of one of the guys had illegally obtained gas rationing coupons in his possession. And one of the questions in this case was, well, does that mean you also have probable cause to search there was other occupants in the vehicle? Probable cause to search them as well. And the court said no. The automobile, and it specifically talked about the automobile exception. It said the automobile exception does not extend to people. You need a particularized probable cause to search the people. So it's not an automatic. Now there is a case that I'm convinced that all canine handlers, when they go through basic canine school, and I'm not a canine handler, I don't have any experience with it, but I'm convinced they're all taught this United States versus Anchondo case out of the 10th Circuit, because I hear it cited very frequently as, well, yeah, I can search the car and the people if the dog alerts on the car, especially if I don't find drugs in the car. So Anchondo is a 10th Federal Court of Appeals 10th Circuit case that said, yes, a dog alert on the vehicle coupled with not finding any drugs in the car is probable cause to arrest the passengers, which of course leads to a search incident to arrest. So it's effectively a search of the persons based on a probable cause alert on the vehicle. Now, a couple things about Anchondo. It's binding only on federal courts in the 10th Circuit. And one of the state courts in the 10th Circuit, I believe it was Kansas, specifically said, we're not going to follow Anchondo.
Right, it is. Yep.
It was a Kansas.
Yes.
Yeah. Okay.
I think it actually might have been. I could be wrong. I think the case name might have been Johnson. Real quick question for you before you continue on is, I don't know. Hopefully this mic is sounding. There's a new mic. I could hear it's like make some weird noises over here. But one question for you is this: I don't want to dissuade people. Is it true that some states have adopted a per se almost bright line rule with the odor of marijuana to search persons inside the car? And I just want, in case anybody's engaged and they're already coming up with this, oh my God, but our court said this, relax. We're going to explain that as we go along. So let's go back to Anchondo. You said absolutely, right? Yeah,
absolutely. And I believe New Jersey is one of them.
Well, it was.
right. Until the legalization. Right. But yeah, so finishing up on Anchondo, there are a few state courts that have said, yep, Anchondo sounds good. We'll follow that. But the biggest problem that I have from with Anchondo, other than it's not consistent with U.S. Supreme Court case law, is that it is a very brief opinion. If you read Anchondo, it is very brief. It gets to the point and says, yeah, the search in this case was lawful under search incident to arrest theory, but it lacks any meaningful analysis as to why the court held the search was lawful. And that's really the key in all case law, is the analysis. So the holding of the case, it was a lawful search, is important to the litigants of this case, the particular people involved in this case. Yeah, that, at the end of the day, they want, was it good or a good search or not a good search. But for the rest of us who are now relying on this piece of case law for future cases, it's the analysis that's important. So if a court were going to reference Anchondo as, well, we've never had this issue in our state, so let's see what other states and other federal courts have to say about it, Anchondo is not going to be a case that's going to be given much consideration because it has no analysis in it. So yes, it's binding on federal courts in the 10th Circuit. I believe it's inconsistent with Supreme Court case law. I would not put any weight on Anchondo if you're not in a jurisdiction that has not already adopted Anchondo's holding, which there are very few. The vast majority of states that have addressed the issue have gone the other way and said, no, you need more than just the dog alert or just the dog alert and not finding drugs in the car.
Mm-hmm.
So,
now we clearly know that some states have adopted it. People ask me this question all the time. Did my state adopt it? What would be a good way of researching if your state has adopted the ruling found in Anchondo, or regarding, the ability to search people after a canine alert? It's interesting. I'm going to jump in here real quick because I don't want to lose train of thought. But when I taught last week in Kentucky, basically the ruling in Kentucky, and I don't expect you to have read it because it was very specific to the Kentucky area while I was teaching Kentucky/Ohio law in tandem. They said basically they wanted to see the canine alerts while people were sitting in the car. If you did that, well, then they can articulate. And they actually said when you did that, because of where the dog alerted and the passenger side door where this person was sitting, it was reasonable to believe that the person could have had the narcotics in their person. So I try to give guys examples of, if this is what they say they want and why they said this was good, well, this is what you're going to have to find. So this articulation beyond just a canine alert, we've talked about this before, you and I, whether it's publicly or privately, people have to understand how to articulate what they're trying to do. So from that point forward, you can go ahead and begin to, I can see you're on the edge to talk.
That it sounds like, and I'm not familiar with that particular case, but yeah, it sounds like it's more than just what Anchondo said. You had the people in the car with the alert, and then it's alerting to a particular location in the vehicle. So kind of the anti-Anchondo case, if you will, what I would consider the leading court, because the U.S. Supreme Court has never had a case like this. D. Ray is from 1948. It's still good law. It's an old case, but nothing involving drug dogs like this has come up. So the leading, what I would consider anti-Anchondo case, is a case out of Virginia called Whitehead V CommonWealth, and it's from 2008 or 9. But this case was a dog alert on a vehicle, no occupants in the vehicle, but it alerted on the vehicle. They searched the vehicle, the officers did, found no drugs, and then they started systematically searching each of the passengers. Ultimately, the last guy they searched had drugs on him. And the reasoning for the search, according to the officers, was we didn't find drugs in the vehicle, therefore they must be on the passengers, and they just systematically searched them with no other facts. And the court in the Virginia Supreme Court said no, the search was unlawful, and it went through a very extensive analysis on why it was unlawful, starting with D. Ray and citing several other U.S. cases. It mentions Anchondo. It mentions the fact that a few courts have followed Anchondo. So this is an example of a court case that could be cited in another jurisdiction in this argument, and it's got a lot of analysis that a court can draw on for its conclusion. And one final thing I guess I want to say about dog alerts and why it's not probable cause to search the people by itself. The argument is, well, I got PCA to believe it's in the vehicle. I searched the vehicle, it's not there. Well, the dog alerted on something, so therefore it must be on the person. Well, the counter argument is that, well, if it's not in the vehicle, then it's less likely that drugs are there because they're not in this particular location, because the dog is not telling you, or your nose if you're smelling marijuana, that there is in fact marijuana in this vehicle or drugs in this vehicle. What the dog is telling you is, hey, there's a good chance there's drugs in this vehicle. If the dog were telling you there are drugs in the vehicle, which is way more than probable cause, then yes, your process of elimination argument would work. If it's not here, then it must be here, here, or here. And the Virginia court actually goes into pretty detailed analysis on that regard as well.
Yeah, I remember reading Florida case law, and they have two courts locked up. One district says this, one district says that. I'm sure I could tell by the smile on your face that you've read them.
Yeah.
And the one court that did not, I think they petitioned the Supreme Court to hear it, and the Supreme Court gave them, what's it called, Satori? Is that what it's written, Satori?
Grant of certiorari. That's
yeah. So fucking terms, I don't know. But what they said was, we know there's residual odor. If John gets out of the car, for example, a week earlier and had crack in his pocket, why is Susan getting subjected to the search because she's in the same car that John was? And the dogs will alert with a residual a week later.
Right.
And that's what they were saying, was the argument there. And then you go to Kentucky, and again, Kentucky made it very clear, and they said, kind of like New Jersey said, but New Jersey's a little strange on this, and we got to talk about that for a hot minute, because I have a question for you as well. And I don't mean to catch you off guard, but I do want to ask you the question. Sure. And we've talked about it in the past, so I won't be catching you too off guard. Just it's been a while since we talked about it. In Kentucky, they said, look, if we say that you can search people in a car when it smells like weed, well, the same principles apply for the dog. But in this circumstances, this is why we allowed it, and it will be on a case-by-case basis. A lot of people ask me questions about, hey, if you get this, and what do you think then? Guys, every single, in our court system, when we talk about investigating, namely, especially motor vehicle stops where we're trying to intercept and interfere with criminal enterprise, what you have on that stop is different in many facets and will be reviewed on an individual case-by-case basis. So there's no blanket answer. What you can do is you can collect all the data and say, I've seen circumstances similar to this before, and it was good. I have what I think I need from this point forward. It should be a good case. Or you could say, you know what? This reminds me of that case that I read where they didn't have enough. I don't think I have enough yet. Let me try to build a little bit more independently to get where I need to be. In the other case, that was good. Now, on a quick side note, there are some states that have said that a canine alert is good to search. Now, New Jersey per se doesn't say that, but what New Jersey does say out of Ponte, and I can't remember the other case name, it was a recent one out of 2019. So we have one from, I think, in the 90s sometime, and then another one in 2019. Essentially what happens in these cases, and I could pull up my computer, I have it right in front of me if I need it, is that with reasonable suspicion and a canine alert for narcotics, one was a person who had luggage, so they knew it was clearly theirs, and the other one was a single occupant vehicle. In those circumstances, without searching the car, with reasonable suspicion that they had, and the canine alert, the courts provided that would be enough sufficient probable cause to place the person under arrest. And they're citing, I think there's actually citing a U.S. Supreme Court case or U.S. District Court, circuit courts. So I can read it if you'd like me to, if that'll help you clarify it. I don't want to catch you off guard.
I mean, they might be citing Pringle. I'm not positive, Meredith.
No, I'll actually, instead of pontificating, I'll just pull it up. I should be able to do this.
Yeah, it was the 90s before Pringle.
Yeah, I'll and again, this is how much we prepare for this. We kind of just go off the cuff. This is to kind of show how good we really are at this stuff, right? No, it's not. It's that we're rushing through things. Let's see. I got my 20 to New Jersey case law. Where is my case law program? Go ahead, Zach. Why don't you say something in the meantime while I'm looking for this in the interim?
So I just want to, I guess, maybe the final thing about Anchondo, and the odor of marijuana or dog alert, you still clearly have enough to detain everyone. If the dog alerts on the vehicle, you may not have probable cause to search everybody at this point until you develop more particularized to an individual. But you certainly have enough to keep everybody detained to figure out what's going on and where these drugs perhaps are located. And a lot of times you have more than just the alert. You have the things that you've seen, the answers to questions that you've asked. So it's, a lot of times we have more than we believe we do. Sometimes we're a little over-reliant on the dog or the odor of marijuana ourselves that we detect ourselves.
Cool. I'm just about pulling up the dog stuff here. I know in my program, just about where I need to be. I'm going to read these cases to you, and I only have short little paragraph blocks that are highlighted because that's all that really mattered.
Okay.
For the point that I have to make, I'm going to give it to you. Let's see what we got. It is going to be, oh, Lordy, back up a little bit. I got Florida v. Harris. Where is this in my program? Here we go, right here. So the first one is, as I said to you, State versus Cancel. I'm sorry, I said Ponte. And this is what they said in Cancel. And I know you don't have it in front of you, so hopefully you can try to ingest it as I say it, maybe process it. Yep. We agree. And again, I've told people, if you are going to perform this action, one, obviously let your administration know before you start locking people up for a canine alert. Know what you're doing. But even though I find that from a legal perspective, what we need is the probable cause to make an arrest, both courts in this said, with the level of reasonable suspicion coupled with the probable cause. And what I give people example is, if you read this case, they talk about all the discrepancies in the stories, all the reasonable suspicion. It'd be a little different than, deploying a dog into a parking lot and having it alert on a car in a parking lot with nothing else attached to it other than the fact that you had a hunch. That's where I'd be a little more apprehensive regarding making an arrest for a canine alert. Here's what it says. This is Cancel 1992. It's New Jersey Appellate Division, and it's a published case. We agree that the dog's positive reaction to the defendant's suitcase and the discrepancy between her name and the name on her ticket gave the police probable cause to arrest her and obtain a warrant to search the suitcase. It's citing Florida v. Royer. Had police used a dog to sniff defendant's luggage, a positive result would have resulted in his justifiable arrest on probable cause. See also United States v. Goldstein, Fifth Circuit, 1981, where it said a positive dog sniff to defendant's furtive behavior and false name on his airline ticket furnished probable cause to obtain a search warrant. Thus, the officers' comment to the defendant that she would be detained while they obtained a search warrant was a fair prediction of events that would follow, not a deceptive threat made to deprive her of the ability to make an informed consent. Compare State versus Dolly out of New Jersey, 1991. And by the way, if you're looking for the case, it's cited next to the citation of 434 in the case, the number in the scroll on the left. Consent deemed involuntary when induced by threat to execute effective search warrant, which is irrelevant to what we're saying here. Now, following up, State versus Nelson 2019, what happens, I'm going to give you a quick preamble. Actually, they have it right in front of me. In October 2014, a New Jersey State Police detective received an anonymous tip from the Bureau of Alcohol, Tobacco, and Firearms. I don't know why they called it an anonymous tip, because you knew where it was coming from. So, I don't know why they put an anonymous tip. This goes back to the language that you're using in your reports, folks. And when you're writing reports, don't forget you're writing a legal document. So when you write anonymous tip, I don't think you understand the difference between anonymous tips, named informants, unnamed citizen informants, and confidential informants. I would call this more of a named informant, if anything. That a silver FX35 with a particular license plate driven by an African-American male will be traveling on the New Jersey Turnpike and transporting a large quantity of marijuana. 13 minutes after receiving the tip, the NJSP spotted the car, made the traffic stop, citing the driver failing to maintain his lane and following another vehicle too closely. So you have the pretext stop there, which I think is very, very smart. Even with good, I always try to advise people, with your knowledge, it may be enough to satisfy that prerequisite probable cause that you would need to make this stop, because we know probable cause, reasonable suspicion is what we need. But attaching the motor vehicle violations, if you have the opportunity to do so, is a real smart idea going forward. So they don't, in case you get something challenged, you might be saving your case with that extra. So I like that there. During the next stop, NJSP Detective Jason Kazan asked Detective Defendant Dwight Nelson to exit his vehicle and read him his Miranda rights. Now, why did he read him his Miranda rights? Because the New Jersey State Police have a policy that on there, this is a SOP. You do not have to do this unless you're a New Jersey State Police officer. They have a policy that on a traffic stop, everybody gets their rights read. Don't ask me who invented that or why they put it in place, but that's a real thing. Detective Kazan noticed an overwhelming smell of air freshener emanating from Nelson's vehicle and that Nelson seemed nervous and sweaty during the interaction. Detective Kazan also found it suspicious that there were 2 large bags in the cargo area hold of Nelson's car, and that Nelson's story regarding his travel plans changed during questioning. Now, with the tip, depending on the source of the information, I think that, and again, I'm not going to jump in here and criticize, a lot of this stuff is, factually deficient. I think this trooper was trying to do a good job of developing even more independent, reasonable suspicion. So not to his fault, but I think with the tip alone, you probably had enough. Again, depends on the source and you've really confirmed a lot with the veracity and independent research regarding the person matching up to the tip. So here's what it goes on. Detective Kazan asked Nelson to consent to search his vehicle, which Nelson refused. Shortly thereafter, Detective Kazan called for a canine unit to come to the scene. 37 minutes later, a canine unit arrived, and the canine alerted the detective to the presence of narcotics in Nelson's car. After Nelson was arrested, the NJSP obtained a warrant and searched his vehicle, finding 80 pounds of marijuana. And let me just jump in here. We do have the automobile exception in the state of New Jersey. However, Zach and I talked about this a little bit last week. That automobile exception comes with one caveat, and that's the circumstances unforeseen and spontaneous. Here, this is one of these situations where we did not have unforeseen and spontaneous circumstances. He knew. However, I will also argue this. If you actually read our case law, it says to obtain a warrant when practicable to do so. Now, do I think it's a good idea that at this point with our case law and how it says it? Yes, there was I didn't find any kind of independent agency. It wasn't a kidnapping victim. I agree with the steps that were taken, but don't forget, it's very rare unless you have pre-existing knowledge like this that you would need. I would actually almost argue that you didn't need a warrant. I don't think it's a bad idea here if you're in that guessing game, because it's not like he had 3 days to go get do you guys do anticipatory warrants in Virginia?
Mm-hmm. Yes.
Okay, so I don't think this guy, had enough time to call a judge in 13 minutes and get an anticipatory search warrant. I would say this is more of a call for service, but they played it smart, and I have no issue with that at all. But if certainly they didn't go and get a warrant and search it after the canine alert, I would argue if you get the right prosecution who knows what they're talking about, which is a rare find, that look, this was a service call. I didn't know this was going to happen. I didn't show up to work. We didn't have a day to think about this. That's my position. Although I'm not criticizing the actions that were taken here, just some food for thought to give everybody some clarity. People get confused with that unforeseen spontaneous thing in, say, New Jersey. And if you're from New Jersey, it really only applies to us. They'll say things like, oh, well, what if I go to a service call? Let's take a shoplifter, for example. You go to shoplifting. The guy says, hey, we didn't get him on video, but we saw him putting the proceeds into the trunk of the car. Would you need a warrant at that point? No, it's a call for service, not unforeseen and spontaneous. I'm sorry. It is truly unforeseen and spontaneous.
I would agree with that.
So go ahead. That's the explanation of it. I see you taking notes. Go ahead and give me.
Nelson, he's the only occupant, and it sounded like is it counsel the first the only
cancel
occupant?
CANCEL. Yeah, right. Again, only occupant. So we get into this situation where you start getting tricky with multiple passengers, right?
You got multiple occupants, but in both of these cases, you had more than just the dog alert. Before the dog was even brought to the scene, it sounds like you already had suspicion of narcotics, certainly in the second one. You already had some suspicion of drug activity.
Yes.
Probable cause to search the car just corroborated that RS that you have. And I think both of these searches, they sound entirely reasonable to me.
But it was the arrest with the canine alert. That was what the arrest was for.
Yeah. So the arrest is for a possession of offense. So you have factors before the dog that indicate this person is in possession of or is possessing with the intent to sell drugs based on the tip that you had. You have the air freshener, nervousness, inconsistent statements about where he's going. So you've got suspicion of drug activity. Then you have a dog alerting to saying there's probable cause to believe there's drugs in the vehicle. So if they're in the vehicle, he's the only one there. You have signs that he's involved in drug activity. So you have coupling all that together, you've got probable cause to believe he's possessing narcotics before you even find the narcotics, because the dog is saying, hey, there's a good chance there's drugs in here. So they're making an arrest. And then so the vehicle search, the search of the person is a search incident to arrest. It's effectively the same as an automobile exception search. But yeah, I think the circumstances of these two cases are vastly different than Anchondo, where you had multiple occupants, no drugs were found in the vehicle, no other indicators of drug activity that was presented on the record. Now, there may have been other indicators, but it wasn't put on the record in the case. It's just a bare bones. We don't find drugs in the car, so we're going to arrest everybody and then search the people. I don't think that's.
Have you heard of any other states where they are arresting in similar circumstances? I mean, New Jersey's the only one I've seen this so far.
There's a couple. Illinois or Indiana, one of the two. Obviously, Kenny or Mike Brazil could tell you about that. I don't think it's Indiana. There's one of those states over there in that area that I think says, yeah, probable cause to search the vehicle for drugs is probable cause to arrest the people.
It may be Indiana because I know Illinois has a carte blanche no bright line rule.
All
Like
right.
Maryland. I mean, you've read Maryland. Maryland says you would only be able to search people with the dog alerts, but a dog alert in this state, we depart from the federal ruling. You do not get to arrest occupants with a canine alert.
And I know North Carolina is a no-go. There's numerous states that say you can't.
And I ask that just because I want to heed caution to those folks who are listening, who are hearing this. You must check with your state's case law to ensure that you can perform this action. If you're in New Jersey, you got it right. But just be very careful. And I want to just keep in mind that there are a lot of people who are newer listening to this and trying to understand and interpret case law. We're doing our best to try to be transparent. And often at times, when you run a police training company, people, listen, throughout the years, you're going to have criticisms. I've been doing this almost 9 years. People have said, dude, and that it's funny because some of them are real big diehard fans when I was new, like, that's a vague way of explaining things. And I've said to people, well, then you fucking explain it, right? Because it's either this way and the best way I know how to communicate it, or no way. So would you rather have nothing? Because nobody, to this day, I mean, my right hand to God and not explained to me that something that they had learned was misinterpreted, misapplied, and it was a big calamity, catastrophe. As a matter of fact, the things that we do are providing clarity, what to do in this situation, when can we apply it. We just got to make sure we're doing a good job of communicating it correctly so you're understanding and applying properly in the field. So
Absolutely.
That's that part there. Good case in New Jersey. Again, I would caution folks, if you do not know how to apply this, you don't have time seasoned in the field, know that it exists. If you don't understand it, don't apply it. By the way, you're also going to make your sergeant shit his pants when you lock somebody up. Zach, I have a question for you. What do you think the charge is at that point? And I'm being a little unassuming here because I kind of know the answer, but just to volley a conversation. When somebody's arrested on a canine alert, what are we charging with at that point?
Possession of narcotics.
Yeah, just a general overall possession of narcotics. What if you don't find anything?
Then you unarrest him.
Okay.
You unarrest him. If you've lost the probable cause you had dissipated, and you would unarrest them. Very simple.
Interesting. And then in your report, you would document that to be an unarrest at that time. But we're allowed to arrest them and unarrest. In New Jersey, I believe we have a requisite where your shift commander, maybe it could have been a thing particular to my agency. I don't know if I thought it was an AG guideline, to be honest with you, where if you're going to unarrest somebody, it has to be done by a shift commander. Does that make sense?
I guess. I mean, we get this all the time. I was told in the academy when I was attending the academy years ago, there's no such thing as unarrest. You can never unarrest someone. And I would argue that if you have someone under arrest and you don't have probable cause, that arrest violates the Fourth Amendment. It's that simple. So you can have probable cause and lose it, because probable cause is just a reasonable belief that can be dispelled when new evidence comes to light. So whether you need to get the approval of a shift commander, that's fine. And I think that's nothing wrong with that. But taking them to the magistrate and then having the magistrate unarrest them, that means you're transporting them to the magistrate under arrest without probable cause. That clearly violates the Fourth Amendment. So
okay.
Yep.
This guy, and by the way, like they did. So when we had the automobile exception a while back, there was very common, because we had to go get search warrants. There was no independent agency ever really, that a lot of agencies or a handful of agencies would arrest, transport back to police headquarters while waiting for the warrant to be issued by the judge. Mm-hmm. Your thoughts on that? Once the warrant was issued, if something was swung and missed, then is that the point we're going to unarrest? We can explain that.
As until we conduct that search, we still have that probable cause. The probable cause is still there. It's not until we do the search that we've lost the probable cause. So yeah, cool. While waiting at the station for the warrant to be issued, they're still under arrest under probable cause.
Remember, we had this prosecutor here that was assigned to our area, and she just could not wrap her head around this concept. And I remember her expressing that to me. I just don't get it. And I'm like, do you get anything? Like, do you know? And her reputation was she didn't get shit. She didn't know what she was doing. And when you began to expose that, it was like poking at a beehive. You want to talk about pissing these adult children off. Adult children, right? Like, I mean, can't. Yeah, and by the way, I didn't know much about this at the time, and you're leaning on these legal experts, and she's like, I just can't wrap my head around how this works. And it, again, it is what it is. I'm not going to make this conversation about who we have to rely upon for police legal, but what I want to implore everybody is we try to be as reliable as possible, do your independent research, and also, count on yourself. Choose yourself. There's enough training products out there now, especially from this company, where we can give you a good insight and a good start as to where to go. And Zach's class, his 2-day program, is phenomenal. I mean, you really will leave with a lot more practical knowledge than probably a lot of people in the field. I think a good 99% of people, as crazy as that sounds. So, next topic.
Let's talk about passengers. So since we're talking about vehicle stops.
Oh, good one.
Let's talk about what's our authority with passengers.
Can I preamble this just a hair?
Please do.
Okay, I travel the country and I will pose this question in class. And I will say to people, by a show of hands in here, who's been told at some junction in their career that when you stop a car, passengers can feel free to immediately depart and walk away from a traffic stop? And I'll say, and we'll get, it depends on the class. We'll get maybe a half or less than half who will raise their hand and said, I was told that. And we'll say, by who? And, we figure out that it's just people who had no idea what they were talking about, just making things up and what their own personal opinion was. And then I'll provide legal documentation that contradicts that. And I'll say, well, the next time you go and you hear that, you can present this, which has happened here in Jersey. Literally, I'll tell you a quick story. Some police legal expert who's insecure teaches this class, and this kid walks up to him and starts showing him case law on his cell phone. And he's reading through it, and he's like, where did you get this from? And the guy's like, what do you mean? He's like, is it true? He's like, well, hold on. Where'd you get this stuff from? And he goes, street cop training. He goes, oh, that guy will get you sued. I go, oh, I'll get you sued. I'm literally sending over the case law and I said to him, you can tell this guy, if you're so adamant, where are the 9 pieces of case law that negate the 9 pieces of case law I gave you regarding Brendan v. California? And, the guy had nothing to say to it. So what I'm proud of here is our ability to challenge the status quo and say to people, hey, if you're going to say you're this, you better be this, because we have people out here who are doing the research and finding out the stuff you're saying isn't true. You have the audacity to stand in front of people and teach them about legal principles. Please be correct. And you know what? There are moments in my career where I haven't been, but I at least had the humility to say, you know what? I was wrong there. My apologies. And that's a big strength. And you'll get a lot of respect from people on that. But anyway, let's go into it. That's the preamble. Have you been told on a traffic stop, people can just depart and walk away? And we know Massachusetts and Washington, relax. Zach will address that, but go ahead with your response.
Again, I'm going to preface it with as a Fourth Amendment matter. This is going to be the answer, and I understand. I know Washington under their state constitution is different, is more protective of citizens' rights, and that's perfectly fine. And I believe Massachusetts has the same condition. But for Fourth Amendment purposes, let me step back 1 second. So normally we're taught, and I even teach the same way, there are 3 categories of officer-citizen contacts, except in New York. There's the Dubauer 4 levels, and I still don't understand the distinction between numbers 1 and 2. Kenneth Rice, hopefully you can let us know the New York expert. But anyway, other than in New York, there are 3 categories. There's a voluntary contact, there's investigative stop, and there's an arrest. All officer-citizen contact fall in one of these categories. Well, there's a 4th one that I've started including in my teaching. It's a seizure category, and it's between voluntary contact and investigative stop. So it's a seizure, but it's not quite investigative stop, and it is the vehicle stop passenger is a 4th category of officer-citizen contact. The reason is they are clearly seized. First and foremost, all occupants on a traffic stop are seized. At least initially, okay, that's what Brendan said. Brendan versus California, 2007 said, when a vehicle is stopped on police authority or in response to police authority, all of the occupants are seized. Brendan was a case where a passenger was challenging the lawfulness of the stop. So it was a case about standing, whether Brendan had even the standing to challenge the stop, and the court said, yes, he was seized at the moment the vehicle stopped. Now, what Brendan didn't kind of left open for debate was, well, what about through the rest of the course of the stop? Does the passenger have to stay there? And again, this is a traffic violation stop, speeding, equipment, something where the driver is the violator. So after Brendan, that issue was cleared up in Johnson, Arizona versus Johnson. The court said clearly all passengers are seized for the duration of the traffic stop on most traffic stops, most traffic stops. And we can talk about when they wouldn't be, but it's a real small outlier set of cases. But anyway, yeah, they're not free to leave. They're seized, but they are seized without reasonable suspicion particularized to them. This is why I categorize it as its own separate Fourth Amendment category. Because if they were seized pursuant to reasonable suspicion, which they're not, passengers, what can we do? We can compel ID from them. But you can't. You cannot compel identification, meaning force the person to ID themselves.
You could always ask.
You can always ask, but when we use the term compel, we're saying we can demand their ID or they face legal repercussions if they don't provide it. Passengers are under no obligation to identify themselves unless you have at least reasonable suspicion to believe they're involved in criminal activity or some kind of violation of the law. That's Hybel, the Hybel versus Nevada.
Sixth District Court, Nevada, Humboldt City.
There you go. Thanks. Great Supreme Court case. All right. So they're seized, but they're not like fully seized with all of the authority that we have. Basically, the only authority you have with passengers is they can't leave. If you want them to stay in the car, you have the legal authority to order them to stay in the car. That's pretty much all you can do. You can ask for their ID.
What if they begin to depart from the car against your authority to hold them there? What kind of force can you use? What kind of charges can we bring against them?
So good question. So and this is going to come down to your state law, state statutory law. But we know they're seized for the duration of the stop. So that carries with it the authority, the implied authority on my part to use a reasonable degree of force to keep them there. So if he tries to walk away, I can use a reasonable amount of force to keep him detained if that's what I want, if I want him to stay. Or I could just say, well, have a nice day. And be on your way. But if I want them to stay, I can use a reasonable degree of force to do that. Now, whether that act of trying to leave the stop without permission and me having to use force, and maybe they put up a little bit of resistance, whether that amounts to a crime is going to depend on your state law. In Virginia, I can tell you from personal knowledge that act by itself is probably not going to rise to an obstruction of justice. It's certainly not resisting arrest because I don't have probable cause to arrest them for anything.
Until they resist.
Until I have probable cause to arrest them for something, and then they continue to resist. So what can I do? I can forcibly put them back in the car and continue with whatever it was that I was doing. So some states, I would imagine most states probably have some kind of statute you could charge them with, but it's going to depend on that.
Yeah, when you say forcibly put them in the car, I mean, in my mind, I'm trying to paint a picture for the people who are listening. You know, as long as they're not resisting and pushing back at you, because then you have officer assault, right?
Yes, absolutely.
Yeah. Hey, you could touch them. Hey, listen, you got to sit back in the car, point back in the car. They get back in, and there's no charge, but you can tell them.
Talking about using minimus level of force, where we're maybe just kind of physically guiding them back in the car. Or maybe we can in the back of our car, perhaps. And
the guy starts to push past you, or the girl starts to push past you. Now we're at a point where we're getting into an officer assault and an obstruction by means of physical force.
Absolutely. And then every state has an assault battery statute that could apply. It depends on the response of the subject. Yes.
Right.
But no, they are not free to leave on their own. They have to stay for the duration of the stop.
And you would say a far majority of states adopt this ruling. I can agree with that.
Well, yeah, they're the only two that I've ever seen. I know Washington, and I certainly take your word that Massachusetts is one. I haven't done a whole lot of research on Massachusetts.
It is.
I'm not surprised that that's one of the states.
It's nuts. I read their case law and I'm like, I start class and I'm like, yeah, you're all fucked. But you're not. They still listen, man. And it's crazy because on the surface level, it's interesting. It's like New Jersey. As liberal as New Jersey is in politics and democratic state, you would be hard pressed to find a conversation where people are very liberal. A lot of that's guided by, I guess, certain areas in New Jersey. But overall, people that it's a very conservative state. You'd be surprised. And the same thing with the state of Massachusetts. It's a conservative state. Like the Boston PD. We have a new instructor, Tommy Brooks. He's got a class coming out called The Gun Game. He's a killer. He's a sergeant in Boston. And he's like, dude, people like us here. Like, they don't give us a hard time. Like, there's a lot of respect for the law enforcement in Boston. It's a very interesting thing. And then you go to their courts and it's extremely liberal.
And that's Virginia's the same way. Outside of your metropolitan areas, Virginia's a very conservative state as well. The reason for passengers being, why the court says they're seized is it's safety. It really just boils down to officer safety. It's not. That's where Mims and Wilson come from, ordering people out of the car. the court recognizes the inherent danger officers face on traffic stops, as do as the danger associated that passengers are associated with. The court defers when an officer determines a particular course of action would be safer on a traffic stop. Courts are very, very inclined to defer to the officer's judgment, and that's the basis for these cases.
When you start, we're probably not going to get to Gant today. We'll save that for the next conversation.
Right.
But let's go into Mims and Wilson just a hair.
Okay.
And, just to give a preamble to this, Mims and Wilson says, Mims comes out in 1977 and says, without reasonable suspicion, an officer can order somebody out of a vehicle on a traffic stop. And then 20 years later, under the Maryland v. Wilson ruling at the U.S. Supreme Court, 1997, they come out and say the same thing applies to passengers in a car. You don't have to have a reasonable suspicion. And that's state by state as well, right? Yes. Most states adopt Mims. New Jersey even has a more of a restriction on Maryland v. Wilson. It's not a crazy restriction, but I can kind of understand why it's done. So what they say is, and the question I have is, what if you give somebody a lawful order to step out of a car in a traffic stop? What's your recourse if they're like, I'm not coming out? And is that vary state by state?
Yeah. So Mims says that, just like you said, Dennis, we can order drivers out of a vehicle without any kind of suspicion. If the officer wants them out of the vehicle, the officer has the authority to order them out of the vehicle. And then they extended that to passengers. There are states that distinguish between passengers and drivers. Like in some states, you don't necessarily have to have reasonable suspicion to order the passenger out, but you got to have some reason why you want them out.
Jersey, they called it heightened caution in Jersey.
Heightened caution. Okay, well, in Wilson, the U.S. Supreme Court said passengers are no less or no more dangerous than drivers. I don't understand the distinction, but it exists. So what do I do? So I order the driver to get out of the vehicle, and he refuses to get out of the vehicle. So again, now we return to state statutory law and officer discretion. The first question I would ask an officer is, who's confronted with this situation, well, why do you want this person out of the car to begin with? Okay, if it's just a matter of routine and you like your passengers out of the vehicle on traffic stops, then I would say, are you going to use force to get this particular person out of the stop? That may not be the wisest course of action. Do I have the authority to do that under the Fourth Amendment? Yes. If I have the authority to order them out, that means I also have to have the authority to carry out that order in the face of resistance. There may not be a state charge for someone for resisting getting out of the vehicle, but that doesn't mean I don't have the authority to physically remove them from the vehicle. But it may not be the wisest course of action. Maybe sometimes a little bit of retreat on our part may be the best tactic. Then just leave them in the car if they don't want to get out. And I don't really have a good reason for wanting them out. Would be my answer to that.
And again, just to remind everybody, this is circumstantial. If there's a supervisor listening to this and going to give people practical advice in the field, I think the first question the supervisor would ask is, well, what do you got here that he's not getting out of the car?
Exactly. Right.
Not carte blanche. You know what Zach said in that podcast? We trust those guys. You're friggin' heroes over there. Zach said in the podcast, just leave them, retreat. Well, that's not exactly the answer every single time. And I often tell people, the more you get good at this, you're able to tell between somebody who essentially is a sovereign citizen style stop and somebody who is really trying to hinder your ability to detect and uncover criminal activity. It's a big difference there.
And one thing that somebody told me years and years ago in a situation like this, and it works in a lot of situations. If I'm troubled by the fact this person won't get out of the car and I'm asking for advice, I would say, well, have you tried asking nicely? Have you just tried asking the person nicely to step out of the vehicle rather than demanding it right off the bat? And asking nicely goes a long way. I think we can both speak from experience. Most people, if you ask them to step out of the car, what are they going to do? They're going to step out of the car.
And by the way, if you can almost tell when somebody's not going to cooperate, when they're already that initial. And again, the question you have to ask yourself is, where are we at? What kind of administrative support do you have? If reasonable suspicion is subjective to the court, are you meeting the criteria your state Supreme Courts and appellate divisions have asked for when maybe calling for a canine to respond to the scene? Is it better just to leave them in the car? It's funny. There's this thing where canine officers are adamant about not leaving passengers and occupants in a car. And I told the guys in Kentucky and the girls in Kentucky, hey, you need to have a conversation with your people about, because you have this piece of case law here. If you're looking to try to search the occupants or at least call that into the realm of possibilities, your canine handlers are going to have to understand they're going to have to leave people in cars. And the excuses that come, oh, it's a safety issue. Really, your dog's some superhuman Belgian Malinois that can penetrate glass and sheet metal. I don't know. And they go to these canine academies where it's been conjured up somewhere. But I just want to reiterate to everybody, I have never read, and Zach, you can correct me if I'm wrong, I have never read a legal precedent or a document that said one way is legal, one way is not. It's just some conjured up bullshit. And that's when we start peeling apart the layers of law enforcement and find out all the silliness that we're subjected to in these conversations. And maybe there's a good reason for it. I'm not criticizing that. But for legal purposes, if you are in a situation where they don't want to get out of the car, maybe you do have articulated enough for reasonable suspicion, whether that's with reaction to presence, your skill level. You may be in a situation where if you don't think it's somebody putting an act on where they want to genuinely not like the police, that you could deploy a dog and sniff it at a very minimum. But you'd have to articulate those reasons to extend the stop. You could just call the dog out of spite because this person's being a dick.
Right. And we talked about this last week, Dennis, that, what you and I are talking about here and kind of what my area of expertise is the law. We're just talking about, but what does the law say you can and can't do? And just because you can do something doesn't necessarily mean it's tactically or by policy the best way to proceed. We're just saying, do I have the authority to order passengers out of the vehicle? Yes, legally I do. Is that the correct course of action in every case, or like physically remove them if they refuse to? I'm sure that's probably not the wisest course of action in every single stop.
I'm thinking about it as we sit here, I'm like, man, there are so many unanswered questions, and hopefully these podcasts that you and I do, and we've agreed to do weekly, are providing a lot of clarity and value to folks. And I can imagine people's wheels are turning as they're listening to this. We implore questions, maybe follow-up stuff from the previous week. You can email dennis@streetcop.com. Please don't send me a lot of emails. Unfortunately, I probably put A to the wayside. People have to remember that this is a very, very large police training company. And unfortunately, I won't be able to answer everybody's stuff. But if you have a follow-up question to some of the conversation we've had in any of these podcasts, and you want your question answered regarding the topics we're discussing, I don't give a shit what kind of duty belt you want. What are the best boots for service? Like, there are so many Facebook groups you can go into, and they can all give you their 936 answers on Danner versus Galls versus Reebok sneakers. Like, that's not what this program or training company is about. We're here to try to help clarify and understand what case law is, how to apply it, how to use it, make sure that you're not going to get yourself in a situation where you can't explain why you took the action that you took. So if you have some kind of question regarding the law that you want us to clarify, and it could be a good topic for us to discuss anyway. And I mean, I probably have 1,000 right now that I really have developed my program off of, and I try to stay in my lane. I really do. I'm trying to give clarity and as much candid explanation as possible while citing the case law. And it's taken time for me to get the trust where people could say, you know what, if he's saying it, he's showing it to you, and he hasn't been caught yet saying something that he shouldn't be saying, here we can inherently rely upon it. And I always tell people in class, fact check it, man. You go and fact check it. Fact checking doesn't mean asking your sergeant. Fact checking doesn't mean calling your police legal advisor and asking them. Fact checking means opening a book, doing the research, and trying to figure out yourself. Unfortunately, your police legal experts and your coworkers are probably not going to know the answers to this. So it falls on, and hopefully we become a reliable source for folks. So did we have anything else regarding that kind of, we're there? I don't want to go into Gantt. It's going to be a long drawn out conversation on Gantt.
Rodriguez, that's a whole nother day.
Oh my God. Yeah.
About Rodriguez issues. It's a really big issue in the federal courts of appeal right now, but that is certainly more than we have for today. Yeah.
Rodriguez is it's in the court appeals right now.
No, it's the Rodriguez issue, the issues that come from Rodriguez as far as extending stops. That is one of the topics that the courts of appeal are addressing with frequency.
Oh my God, yeah.
Rodriguez came out in 2015 in the U.S. Supreme Court.
Right.
A lot of cases that are being appealed on Rodriguez issues. So it's very important we talk about it.
And just a little purview into next week regarding the Rodriguez issues. And Zach, you could think about this, and I'm sure you're going to agree with it immediately. The one way to fix Rodriguez issues is to understand and know how to articulate reasonable suspicion.
Oh, absolutely.
That's basically the entire fix of Rodriguez issues. Is there's a lack of articulation, but don't forget, You also have very liberal judges that are not ruling in favor of law enforcement, and it's 50-50, right? So you may have enough in one courtroom and far less in another. And unfortunately, that is the legal system. We had a guy in the group who said, I can't believe you would say something like that. I go, but it's true. You show up in one court, you have plenty of reasonable suspicion. You show up in another one, and you have not enough. So how could it be fair across the board when you're taking that's why they're called a judge. You're taking a subjective opinion. And unfortunately, it is not fair. And sometimes, fortunately, it's not fair. You know what I mean? So it's both.
No matter how much we try to make probable cause and reasonable suspicion objective standards, at the end of the day, they're subjective. So.
There's no question about it. All right, cool. Listen, man, it's been a great one. We'll get back with you guys next week. Really having a great time doing these podcasts. I feel like people are going to find extreme value. I'm also going to post this video in the Facebook group. If you're not part of our Facebook group, it's free for police officers. Got to answer the 3 questions, guys. If you like this podcast, rate it, tell your friends about it, join it, whatever you got to do on Apple iTunes and every platform, Spotify and Podcast Addict. And we have an Instagram page, Street Cop Training. We also have the Street Cop Conference coming up. If you don't know, we just booked Marcus Luttrell. Zach, you souped about that one?
I'm stoked, man.
Yeah, I bet. And you got that insider, instructor, handshaking, picture taken. But we are going to have to lay some ground rules with Tommy Lauren on this. And I've explained that quite a bit. And I've told people in class, she does not want to hook up with your ass. She's dating MLB stars and she's got a lot of fame. The last thing she wants is a $48,000 a year cop, with a 5 and 2, and you can only see her on Tuesdays and Wednesdays. She ain't gonna be down with that. So streetcoptraining.com or streetcop.com. The Street Cop Conference coming up October 4th through the 8th, Atlantic City, New Jersey. We got a lot of people signed up already, but we can fit 6,000 in that room. But ladies and gentlemen, what an all-star lineup. You would not want to miss out on that. Without further ado, Zach, thanks for being here this week. And we will see you guys next week for more Street Cop Training podcast. Take care.
Sounds good.